Settle down, please. Welcome, KSLU law students, to this definitive masterclass explainer. I am your professor for today, and we are going to meticulously break down question 27 of the Indian Contract Act 1872, covering bailment, pledge, and the rights of a finder. Take out your notebooks and pay strict attention. This session is designed with one single, uncompromising objective: to secure you maximum marks for this highly repetitive 16-mark university question. We will not be cutting corners. We will follow a rigid, strictly exam-oriented approach, okay? Let's dive into this immediately. Here is the exact agenda we will follow. 1. Introduction to possession rights. 2. Defining bailment and pledge. 3. Distinguishing bailment and pledge. 4. Rights of a finder. 5. Landmark case laws analysis. And 6. Conclusion and exam strategy. Let's start with Section 1, Introduction to Possession Rights. Read the text with me carefully. Governed by the Indian Contract Act 1872. Deals with delivery of goods and rights from possession. Write this exactly. Now, let me establish a rule immediately. I expect you to absolutely reproduce the agenda structure we just covered on the very first page of your KSLU answer scripts. It shows the evaluator you are a prepared, top-tier candidate. Furthermore, a perfect answer never abruptly starts with definitions. You see, it begins with a strong introductory anchor. Dissect this with me. These foundational principles of delivery and possession set the stage for your entire 16-mark answer. Bailment and pledge are not about ownership. They are strictly about the transfer of possession. Make sure you heavily underline Indian Contract Act 1872 and the word possession in your introductory paragraph. This immediately signals that you understand the core underlying framework. Moving on to Section 2, Defining Bailment and Pledge. Listen carefully to the statutory definitions. Bailment, Section 148. Delivery of goods by bailor to bailee for a purpose. Upon contract, goods shall be returned or disposed. Students, it is critically important that you underline Section 148, Bailor and Bailee on your script to instantly secure the evaluator's attention. Think of giving your laptop to a repair shop. You are the bailor, the mechanic is the bailee, the repair is the purpose. Once repaired, it must be returned. Mark my words, if you miss mentioning for a purpose or shall be returned, your definition is legally void. 0 marks for that section. Let's move to our next definition. Read it with me. Pledge, Section 172. Special bailment where goods are delivered as security for a debt or performance of a promise. A pledge is essentially a specific subset of a bailment. You must point out to the examiner that every pledge is a bailment, but not every bailment is a pledge. When writing this out, you must heavily underline the phrase security for a debt. For example, depositing your gold jewelry at a bank to secure a loan. The gold is the security. Are we clear? Now for Section 3, Distinguishing Bailment and Pledge. I am announcing right now that this precise comparison is where you will consolidate the bulk of your marks. A clear, structural grid is what distinguishes a first-class student from an average one. I expect you to literally draw this precise table on your exam sheet using a pencil and scale. Let's carefully read out and explain each basis of difference. First, nature. Bailment is general, whereas pledge is a special type of bailment. Second, purpose. Bailment can be for any purpose, repair, safe custody, transit, but pledge is strictly for security for debt. Third, parties. In bailment, they are Bailor and Bailee. In pledge, they are the Pawnor and Pawnee. You must use these specific legal terms. Do not use layman's terms. Fourth, right to sell. In bailment, there is no right to sell. The Bailee cannot sell your laptop. But in pledge, the Pawnee can sell on default. If you don't pay the gold loan back, the bank sells the gold. Fifth, right of use. Bailment allows use as per contract. Pledge allows only limited use, usually none at all. It is just kept as security. Finally, remedies. Bailment has limited remedies, mostly suing for charges. Pledge has wider rights, including sale and retention. Contrasting these limited remedies of bailment with the wider, powerful rights of pledge demonstrates a deep statutory understanding. Let's proceed to Section 4, Rights of a Finder as a Non-Contractual Bailee. We shift our lecture focus now to the second half of question 27. When a person finds goods belonging to another and takes them into their custody, what happens in the eyes of the law? The text states clearly, finder of goods has the rights of a bailee, though not a bailee by contract. Please note this carefully. This is a crucial legal fiction. The law imposes the status of a bailee on the finder to protect the goods. There is no offer, no acceptance, no formal contract between the true owner and the finder. Yet, by operation of law, a quasi-contractual relationship is born. The finder must take as much care of the goods as a man of ordinary prudence would of his own. Let us read the first set of rights. Right to sue for reward if promised. Right of lien, meaning to retain goods until paid. Right to sue for reward, specifically if announced and known. Right to compensation for trouble and expenses incurred. Students, clearly bullet point these on your answer script. Do not merge them together into a messy paragraph. Expanding on these, if an owner offers a reward for a lost dog, the finder has the right to sue for that exact reward. Crucially, the right of lien means the finder can lawfully hold on to or retain the found goods until the true owner compensates them for the trouble and expenses taken to preserve those goods. Continuing with the rights. Right to sue when found, meaning they may retain goods even if the reward is known later. File suit against wrongdoer for loss or injury to the goods by a third party. Sell goods if perishable or if lawful charges equal 2/3 of the total value. I must explicitly point out the technicalities here. The right to sell is an extreme right. You can only sell someone else's goods if they are, say, fresh tomatoes, meaning they are perishable, or pay very close attention to the strict statutory threshold if the charges for keeping the goods safe amount to 2/3 of the goods value. Evaluators actively scan your paper looking for that exact 2/3 value fraction. If it is there, you get the mark. If it's missing, you lose out. Section 5, Landmark Case Laws Analysis and Application. Students, heed this warning right now. An answer in a KSLU examination without case laws is an incomplete answer. It will never score full marks. Case laws are the lifeblood of your legal arguments. First case. Read it carefully. Hollins v. Fowler, clarified rights relating to possession and bailment principles. I explicitly instruct you, write this case law in a separate, neatly boxed format on your answer script. Underline this case name immediately to capture the evaluator's attention. Let's break down the background. In Hollins v. Fowler, Fowler was the true owner of cotton bales. A rogue fraudulently obtained them and sold them to Hollins, who was a cotton broker. Hollins then sold them to a third party. The final ratio decidendi of the House of Lords was that any person dealing with goods without the true owner's authority, however innocently, is liable for conversion. What is the absolute relevance of this case to our topic? Why does it matter? It cements the core legal provision that possessory rights are fiercely protected within bailment frameworks. Even a bona fide purchaser cannot defeat the true owner's right to possession. Second case. Union of India v. Amar Singh, recognized rights of finders similar to Bailee. Again, I demand the boxed format for this case on your exam paper. The facts here are vital. Goods were booked via the railway authorities by Amar Singh, but during the transit and subsequent turmoil, the goods were lost or misappropriated. The Supreme Court's verdict, the ratio decidendi, held that the railway authority, by taking the goods into their custody, assumed the heavy responsibilities of a bailee. What is the absolute relevance here? This landmark judgment acts as the definitive judicial backing for the finder's non-contractual bailee status. It proves that a formal written contract is not strictly required for the duties of a bailee to attach to whoever has lawful possession of the goods. Finally, Section 6. Conclusion and final exam tips. We have thoroughly constructed the body of your answer. Now we signal the final wrap-up of the answer script. A strong conclusion leaves a lasting impression on the evaluator. Read the conclusion verbatim with me. Bailment and pledge defer in purpose. The finder protects possession and claims compensation. As you write this out in the exam, you can expand on it to clarify that they are closely related but differ in purpose and rights. And the finder of goods, though not a contractual bailee, enjoys significant rights to protect that possession. For your final exam strategy, let's review. Use clear headings, draw the distinction table perfectly, use bullet points for the finder's rights, explicitly mentioning that 2/3 rule, and prominently box your case laws like Hollins v. Fowler. Now, I leave you with a provocative academic question to ponder. Considering the right to sell upon reaching the 2/3 expense threshold, is a non-contractual finder's right ultimately stronger and perhaps more aggressive than a standard contractual bailee's? Think about it. Master this exact structure and you will secure your 16 marks. Class dismissed.